you don't kill me, you're stupid. So next time you see me, I will kill you.
Some moments in courtrooms are so shocking, they stop everyone cold. Judges freeze mid-sentence, jurors stare wide-eyed, and even hardened attorneys are left speechless. They're not scripted drama, they're real, and when they happen, they can turn a trial upside down in seconds. Sometimes it's a defendant cracking under pressure. Other times it's a witness blurting out something no one saw coming. And then there are the moments when a single sentence, just a few words, can undo months of legal strategy. Today, we're looking at real-life courtroom confessions that stunned the public and blindsided the legal system. From last-minute guilty pleas that blindsided prosecutors to jaw-dropping admissions in the middle of testimony, these are the moments where the truth slipped or exploded into the open. Chapter 1, Jodi Arias Murder Trial, 2013. The murder trial of Jodi Arias was already a media spectacle before she ever took the stand.
This is July 15th, 2008. Jodi Arias has been arrested.
She was accused of brutally killing her ex-boyfriend, Travis Alexander, in 2008, and stabbing him nearly 30 times, slashing his throat, and shooting him in the head. Arias had told police 3 different stories throughout the investigation. But by the time the trial started in 2013, her official version was self-defense.
Did you kill Travis Alexander?
Absolutely not. No, I had no part in it. Travis being attacked by 2 other individuals.
Jodi Arias changed her story yet again. She acted in self-defense.
In most criminal trials, defense attorneys avoid putting their client on the stand. Cross-examination is dangerous territory, and one slip-up can destroy a defense. But Arias took the gamble, testifying for an unprecedented 18 days. Her story shifted under pressure, and the most jaw-dropping moment came during prosecutor Juan Martinez's relentless questioning. Martinez confronted her with evidence that contradicted her claims: timestamp photos, blood patterns, and her journal entries. At one point, Arias admitted to actions she had flatly denied in earlier testimony, including being present during events she once claimed she couldn't remember. She conceded key details, not a full confession to murder, but enough to undermine her self-defense narrative. The courtroom was tense. You could feel the gallery leaning forward, waiting for what she might say next. Jurors took furious notes, and the prosecutor didn't let up, knowing every inconsistency was a gift to the state's case. Legally, this wasn't a confession in the traditional sense, but in trial strategy terms, it was devastating. Her credibility took a massive hit. For a defendant claiming self-defense, the jury's belief in her version of events was everything. And in that moment, the gap between her words and the evidence grew too wide to ignore. Arias was eventually convicted of first-degree murder. Her testimony, meant to save her, may have sealed her fate.
It is ordered. The defendant shall be incarcerated in the Department of Corrections for the rest of her natural life with no possibility of parole.
Chapter 2, Chris Watts' Plea, 2018. Chris Watts didn't just deny killing his family, he played the role of the grieving husband on national television.
I want them back now. Like, that's what's in my head. Like, if they're safe right now, they're going to come back.
In August 2018, just days after his pregnant wife, Shanann, and their 2 young daughters vanished, he stood in front of news cameras, pleading for their safe return. His voice shook, his hands gestured earnestly. He told reporters he had no idea where they were.
I hope that she's somewhere safe right now and with the kids.
Behind the scenes, police already suspected him. His story didn't add up. Neighbors noted his strange behavior, and when investigators confronted him with evidence, security camera footage, GPS data, and a failed polygraph, his facade began to crack. Still, most expected the case to go to trial. The charges were stacked: multiple counts of first-degree murder, unlawful termination of pregnancy, and tampering with a body. The prosecution signaled it might seek the death penalty. The legal fight was expected to be lengthy and intense. Then, in November 2018, Watts walked into a Colorado courtroom and blindsided everyone. He pled guilty to every charge. No bargaining, no not guilty posture, no dragging the case through months of testimony.
Entered a plea of guilty to all 9 counts in the original complaint and information. Those counts include murder in the first degree.
His lawyers later said the plea was his decision, a way to avoid a death sentence and spare Shanann's family the agony of a trial. The courtroom was silent as the judge read the charges, and Watts answered guilty each time. Family members wept. The prosecution laid out the horrifying details, how he strangled Shanann, then smothered his daughters before dumping their bodies. It wasn't just a confession. It was the abrupt end of a story the defense had barely begun to tell. Legally, the plea ensured Watts would spend the rest of his life in prison without the possibility of parole. But it also denied the public the open court unraveling of his lies. For the families, the confession brought both closure and lasting trauma. Chapter 3, Richard the Iceman. Kuklinski, 1988. Richard Kuklinski was a walking contradiction, a devoted family man at home, cold-blooded contract killer at work. By the time authorities closed in, the man known as the Iceman had spent decades working as a hitman for organized crime. His arrest in 1986 came after an elaborate undercover sting, and by 1988, he was in court facing multiple murder charges. The prosecution had enough evidence to put him away for life, but what stunned the courtroom wasn't just the case they built, it was what Kuklinski volunteered.
I shot George Malvin 5 times. Louis Masgay on July 1st, 1981. I shot him once in the back of the head.
In the middle of the proceedings, he casually admitted to killing far more people than he was charged with. He claimed the real number was over 100. He spoke about it with no visible remorse, describing some killings in chilling, matter-of-fact detail. For prosecutors, this was both a revelation and a frustration. Many of the alleged murders fell outside their jurisdiction or lacked the evidence to prosecute, but Kuklinski's own words, spoken in open court, carried a weight that no witness testimony could match. It wasn't a deal. It wasn't a plea bargain. It was ego.
I've went up against people. You could pull a gun on me, and if I'm mad at you, I'm coming forward.
A man who wanted the world to know how dangerous he had been. The effect in the courtroom was surreal. Some jurors shifted uncomfortably. The gallery sat frozen. The defense had no way to reel it back in. You can challenge forensic evidence. You can cross-examine witnesses, but you can't unring the bell when your client tells the world he's killed 100 people. Legally, the confession wasn't necessary for a conviction. The prosecution already had him dead to rights, but it guaranteed that no future court would take mercy on him. Kuklinski was sentenced to life in prison, later adding more time for subsequent convictions. He would die behind bars, his arrogance having slammed the door shut on any possibility of leniency. Chapter 4, Dr. Conrad Murray, Michael Jackson case, 2011. When pop icon Michael Jackson died in June 2009, the world was stunned. His personal physician, Dr. Conrad Murray, soon became the focus of a manslaughter investigation. Prosecutors alleged that Murray's reckless administration of the surgical anesthetic propofol caused Jackson's death.
Michael Jackson's personal doctor, Conrad Murray, directly led to his premature death at the age of 50.
By the time Murray's trial began in 2011, the prosecution had built a case around negligence, but the most damning evidence came from Murray's own mouth. During the trial, jurors heard a recording of his police interview conducted just 2 days after Jackson's death. On that tape, Murray admitted to giving Jackson propofol in his bedroom as a sleep aid, a dangerous and medically unjustifiable practice outside a hospital setting.
This is just a medicine
what
that he was familiar with.
What is the medicine?
It's called propofol.
The admission undercut any argument that Jackson had somehow administered the fatal dose himself. Murray tried to frame it as a compassionate act for an insistent patient, but the recording played in court left little room for ambiguity. It was, in effect, a confession that he had performed the very act the prosecution said caused Jackson's death. The atmosphere in the courtroom shifted as the tape rolled. Jurors listened intently. Some shook their heads. The prosecution didn't need to twist his words. They simply let Murray speak for himself. Legally, the recording was a goldmine for the state. Unlike live testimony, where a witness might backtrack or clarify, an audio-recorded statement given shortly after the event has a raw, unfiltered quality. Murray wasn't just giving facts, he was narrating his undoing. The jury convicted him of involuntary manslaughter.
We, the jury in the above entitled action, find the defendant, Conrad Robert Murray, guilty of the crime of involuntary manslaughter.
He served 2 years in county jail. While the sentence was far shorter than public outrage might have demanded, the case became a textbook example of how a defendant's own statements can be more damaging than any cross-examination, especially when they're preserved on tape and played for a jury. Chapter 5. Daryl Brooks, Waukesha Parade Attack in 2022. The trial of Daryl Brooks was unlike anything most courtroom veterans had ever seen. Brooks was accused of intentionally driving an SUV through a Christmas parade in Waukesha, Wisconsin, killing 6 people and injuring dozens more. The evidence against him was overwhelming. Eyewitness testimony, video footage, and forensic evidence all pointed in one direction. But Brooks made a decision that would define the tone of the entire proceeding. He fired his attorneys and represented himself. What followed was a chaotic legal spectacle. Brooks argued with the judge, refused to follow courtroom procedure, and launched into rambling, irrelevant speeches. But the most damaging moments came when, in the middle of these tirades, he made statements that undercut any possible defense. He acknowledged facts the prosecution had to prove, including his presence behind the wheel, while simultaneously insisting he was being unfairly treated.
I need to make a record too. When am I going to get the chance to do that?
At one point, while cross-examining witnesses, Brooks slipped into the first person when describing events, inadvertently placing himself at the scene in the way the state alleged. The jury didn't miss it, neither did the judge, who remained composed and methodical, despite Brooks's erratic conduct. Legally, Brooks's self-representation was a disaster. A trained defense attorney could have objected, steered questioning away from self-incrimination, and focused on poking holes in the state's case. Brooks, by contrast, handed the prosecution soundbite after soundbite of damaging admissions, all in front of the jury. In the end, the jury convicted him on all counts, and he was sentenced to multiple life terms without parole.
We, the jury, find the defendant, Daryl E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information.
The trial was a stark reminder that in the legal arena, the right to represent yourself also comes with the right to destroy your own defense in real time. From Jodi Arias' unraveling testimony to Chris Watts' abrupt guilty plea. From Richard Kuklinski's ego-driven body count to Conrad Murray's recorded self-incrimination. And finally, Daryl Brooks' self-sabotage in a courtroom he tried to control. Each of these moments shows just how quickly a trial can pivot when the wrong words come out at the wrong time. Confessions in court aren't always about telling the truth. Sometimes they're about breaking under pressure. Sometimes they're calculated moves for leniency. And sometimes they're just slips, moments when ego, anger, or arrogance override common sense. Thanks for joining us today at Due Process Daily. Throw us a like and consider subscribing to the channel to help us grow.